Great. Sorry about that, everyone. We are back and have our technical difficulties fixed. So we're continuing introductions. Chris?
I would be Chris Bradley. I'm President and Executive Director of the Vermont Federation of Sportsmen's Clubs. We're an organization that represents approximately 50 fish and game clubs with approximately 14,000 members.
Great. Thank you.
Thank you.
David Cunin, here with, on behalf of the Craftsman Group.
Great. Thank you.
I'm Calista Smith. I'm one of the law students working at the Office of Law.
Great. Thank you. All right. So, Eric, I'm going to turn it over to you to start the walkthrough. Do you want to do one whole walkthrough without questions, or do you want questions along the way? How do you like to work?
I usually am questioned during.
Okay.
But that doesn't mean it has to be that way, but I'm perfectly fine with that.
All right.
Happy to have people interrupt whenever something occurs to you, or
Okay.
sometimes I might say, let me just finish this little sentence first or something like that, just to finish a concept, but I'm happy to be interrupted.
Okay.
That works better for you.
Yep. Let's plan on that. Again, just direct all questions. Raise your hand so we can keep an order, and let's get started.
All right. Shall I start sharing the screen?
Yes, please.
All right.
Let me actually, as you're doing that, start with one thing. So one of the things that did not make it into this draft are findings. And so Leslie actually last night last 2 nights, I think, worked through a document that she shared with me with findings. And when we realized this morning that the findings weren't in, we were able to use that document. And so Eric has some findings that we'll be sending to him. You may already have them. So we'll start with why we're doing this. Some of the data we've had presented to us in testimony. Great. Thanks, Eric.
Sure. Again, Eric Fitzpatrick with the Office of Legislative Counsel, here to talk to the committee about some language that you're considering with respect to firearms procedures and their connection to suicide prevention. The bill right now, as you probably indicated at the beginning, is framed as a House Healthcare Committee bill, but we can easily wrap that into H230 or whatever bill it is that you're going to use going forward. I was just putting it this way to sort of have some document to have it in for purposes of reviewing it today. But that's easily done. So however it is that the committee wants to finalize it, we can do that for you.
Right.
So, the sort of big picture, before we look at the language of the bill, is, well, what are the big picture concepts that are going on in the bill? I'd say there's 4 of them. One is a requirement that's known as safe firearm storage. So you've got a safe storage, essentially, for short, is what is often referred to as that concept. It requires that a person keep firearms under a premises that they own or control if they reasonably know or should know that it could be accessed by either a child or a person who's prohibited by law from possessing firearms, then it has to be stored in a certain way. And we'll talk about the details of what that means, but that's the big picture. Safe storage required for someone who owns a premises or controls it. In other words, it could be, for example, a renter who doesn't necessarily own it, but that's their house. And that's when this storage requirement would kick in. And we'll talk about, as I said, what the storage requirement actually is, but that's one big picture. Another big picture element that's in here is an information distribution requirement. So there's information about safe storage and about Vermont firearms law that's required to be distributed by Department of Health, by federal firearms dealers. So in other words, when federal, they're called FFLs, federal firearms licensees, that refers to a person who is licensed to sell firearms by the federal government. And you have to be, if you're in the business of selling firearms, you have to get this federal license. So information will have to be distributed by them, as well as by the Department of Health and the Agency of Education. So that's part number 2, information distribution. Part number 3 has to do with what's known, and I don't know if the committee has had any experience dealing with this, or you may recollect it, but there is a law on the books in Vermont called, for short, it's referred to as an ERPO law, but ERPO, E-R-P-O, stands for Extreme Risk Protection Order, ERPO. That law is on the books right now. It allows the Attorney General or a state's attorney to petition the court for an order to prohibit a person from possessing firearms if they've demonstrated they're a danger to themselves or others. That's an existing process passed in 2018, I believe it was. And as I said, the party who can file that petition right now under existing law is the Attorney General or a state's attorney. The proposal here, this is big picture number 3, Proposal here is to add to that list of people who can go into court and file this petition, add two other potential parties, family member or household member. So that's big picture number 3, just a point about that conceptually too. Good to understand this as background. On the books right now is another legal process known as, you probably have heard of it, RFAs, Relief from Abuse Orders. It's been on the books for a long time. The reason I note this is because when I drafted this ERPO law in 2018, I based it on the existing RFA law as well as other state ERPO laws, but sort of for structure and how it was going to work procedurally and all that, we had this model already in law, which allows a person to go into court, get a petition from the court, in that case, to order someone to stay away from a person, to stop their abuse of a person if they can demonstrate that there's been abuse in the past. That's the RFA process. The reason I note that is because the RFA process already allows family members and household members to file petitions, as well as law enforcement officers, state's attorney, that sort of thing. That was not included in the ERPO law when it was originally passed. It was limited to AG and state's attorneys, but helpful to know that that's where that concept is already there as well. That's number 3. Excuse me. Point number 4, the big picture is a waiting period. So the last piece of this is a waiting period, 72-hour waiting period, with a few exceptions, but generally speaking, for most firearms transfers, there would be a 72-hour waiting period between the time that that you pass the background check and when the transfer happens. So background checks also is a separate, it's not dealt with in this bill, but there's a separate provision on the books in Vermont, also passed at least between private persons. That was passed in 2018 also. Firearms transfers by these dealers that I mentioned, the FFLs, the federally licensed dealers, they already have to do a background check if you go in there. In 2018, Vermont passed a law that added that to private firearms transactions. Again, some exceptions, family members, that sort of thing. So when that background check is completed, is when the 72-hour clock starts kicking. So that's the waiting piece of it. So that's the big picture. Can pause there for a moment if anybody has any big picture questions, or we can look at some of the details of how all that works.
Anyone have any questions? Or we just dive in? Go ahead, Mari.
Clarify that, repeat that last part. So once the Charleston loophole, that's 7 days now. And then it's 72 hours.
Well, what is sometimes referred to, the legal description of that is the default proceed. You're referring to it as the Charleston loophole, same idea. That's the idea that, see, when a background check gets started, when the federal bureau contacts NICS, the National Instant Criminal Background Check System, when they contact them and say someone's here and wants to purchase a firearm, they can contact them by telephone, or they have an email electronic system as well. Usually the response they're going to get is, usually there's 3 responses you can get. You can get proceed, it's all good. We checked the criminal history background check records. We checked all their databases that they maintain at NICS that they look at, and nothing got flagged for that person. Didn't come up with any disqualifying convictions, or that they've been involuntarily committed to a hospital, whatever it may be. So that's one possible answer, right? Go ahead. Another possible answer is, do not go ahead. This person got flagged. They've got a disqualifying conviction, something like that. There's a third possible answer, which is, we're flagging it for a second. We're not sure. It looks like there may be a disqualifying circumstance. We're not sure. That's when what you just mentioned, Representative Cordes, that's when that kicks in, that default proceed, because they can hold it. If they can't they say, look, we can't give you an answer right away. We've got to do a little bit more investigation. We've got to see did this conviction really count as one of the convictions that disqualifies a person. We have to look into it further. Under federal law, after 3 days expires, if they haven't been able to give you an answer, they can go ahead with the sale. That's called a default proceed, because they haven't actually gotten a clear for the person, right? They haven't gotten a thumbs down on the person yet either. It's still in process. They haven't been able to give an answer, but the federal law permits that sale to go ahead anyway. 7 days, that was referred to as the Charleston loophole. What happened in Vermont last year was that 3 day period got extended to 7 days. So now there is still a default proceed. In other words, if they can't get an answer within a certain period of time, they can still go ahead with the sale, but now it's 7 days, not 3 days. So brings us back to your question, when does the 72 hours kick in? It kicks in if you get a green light, essentially. If you're all clear on the background check, then the 72 hours starts right then, right? And the vast majority of firearm transactions do get that. I don't know the numbers. I'm sure Chris will easily correct me, but I almost think it's upwards of 90%.
Yeah,
But
that's what we remember, yeah.
that's what I thought. So in those cases, the 72 hours starts right then because they've gotten the answer back from NICS. They get the answer. Look, the person is clear. Clock starts ticking. Obviously, if the person gets denied, it's not really relevant in that case, right? Because they're not going to get it in any event. But if it's not a clear answer yet, they can't give a definitive answer, and they've given a do not proceed yet answer, then yes, that 72 hours would start ticking until the end of the 7 days, or actually until that's what I would do there. That's when the 7 day period ends, unless.
The end of the 7 days or an approval, whichever comes.
I'm just going to say, it could be that they found out earlier,
Yeah.
after 3 days or 4 days or 5 days, whatever. If it were earlier, then it would start. Well,
Okay, thank you.
So if it's in Vermont law now to 7 days,
right.
why are we reducing that to 3? Is that what we're doing?
No, it only applies if that 7 days only kicks in the small percentage of cases when someone who's gone to purchase a firearm isn't able to get a clear answer from NICS about whether they're prohibited.
Right.
That's the only time that 7 days occurs. And even then, if that did occur, this would tack on an additional 72 hours to whenever they got their answer. So let's say it didn't take the whole 7 days, it took 5. And NICS is finally able to search the record and say, all right, well, actually, it's okay. We cleared it up. We thought there was a problem. There isn't on day 5. That's when the 3 day period, the 72 hours that clock would start ticking.
So that would be 8 days.
Correct. In those instances.
Right.
Okay.
And we can get the numbers of how many fall on that. Art?
This would apply the 72 hours to all gun sales from every outlet, like a Dick's sells hunting rifles. I travel to Vermont to hunt deer season and go into Dick's to buy a weapon, and I have to wait 3 days to get it.
Yeah, from a licensee like Dick's, definitely would apply. Yeah.
It would definitely apply,
Yeah.
so.
Yeah, assuming that there wasn't some other exception, but under federal law, but
There's no-
for the most part, it would apply for all these stores, licensed stores that you buy it from, including a place like Dick's, yeah.
Okay, so, but today, I can go into Dick's, buy a weapon today, I get cleared, I can pick it up and go leave, right?
I believe that's, the answer to that is yes. I don't think there's
Okay, but this
anything
would
that,
tack 3 days onto that.
right.
Yeah, okay.
Yep.
Yeah.
All right, let's start walking through the language.
One last little piece that I wanted to mention on my sort of big picture explanation, and this really in a sense is a description of what I'm not describing, which is that there is also an important constitutional background against which firearms legislation has to be considered. And it's particularly important now and particularly unknown now and uncertain because about 7 months ago, last June, the United States Supreme Court issued a major decision on the Second Amendment that significantly changed the analysis that has to be done when firearms regulations are considered. Significantly changed. It is so recent and the subject of dozens and dozens of currently pending cases throughout the country that literally decisions are coming down every few days. And the big picture understanding of that is that there's a lot of uncertainty. And so I think that when new firearms legislation is passed, you have to expect that it will be litigated, it will be challenged in court. You have to expect that there's a chance it will be struck down. And to be an honest assessment of that Supreme Court decision would have to conclude that it's more likely that they'll be struck down now than it was under the previous analysis. Now, that's not a guarantee, doesn't mean that definitely will get struck down. I think there's already litigation all over the country on this, and people are arguing, the history of firearms regulation, which is an important part of what's got to be considered now. From many perspectives, and it's important for the committee to know that you shouldn't be surprised when any new firearms legislation is going to be tested in court.
And that's one of the reasons of many that this bill, if it's passed out of here, would go to judiciary for them to have a look at it. But even they would, be under the same thoughts that it could be challenged at any time. Brian and then Alan.
So actually, a constituent texted me a question that I think is appropriate at this moment. They said that something happened in California in a lower court where the court ruled that the gun legislation was not constitutional. And their question was, if that happens in California in a lower federal court, like in that case, it had to do with magazine capacity.
Mm-hmm.
Does that render our law null, or does someone have to sue the state of Vermont to? And I said to them, I think they would probably have to sue the state of Vermont, or we would have to change the law. What is the correct answer to that question?
The latter answer is the exact correct answer. It has no effect on.
So that either we have to be sued or we have to decide to change the law to become. But if we leave the law as it is, it remains until someone sues it in a federal court or rules it.
In the Vermont.
Okay.
Federal court that has authority.
Jurisdiction here, or the Supreme Court.
Or the Supreme Court.
All right, thank you.
Yeah.
Alan?
When you say the 72-hour waiting period,
Right?
so if a citizen goes in to buy a gun today, if they've got a clean record, they can pick that gun up today. Okay, if they have a flag,
Yep.
can you give some examples of what these, a DWI 40 years ago, would that be a flag?
Generally, no, because it's not a felony.
So it's gotta be a felony.
Gotta be felony under federal law, yes. But yeah, it could have been a long time ago. That is possible in terms of how long ago it was. It's also one of the ways that it works is that if you've gotten your conviction expunged, then you're okay. Then it doesn't come up under the NICS background check system anymore. So sometimes, every state's different about what criminal convictions can be expunged. I can't remember if the Vermont expungement law permitted first-time DUIs.
Changed the law recently.
Yeah, it changed recently, and I can't remember if DUI ones were included. But that's another way you could go about it. But it has to be a felony, though, generally speaking. Which means 2 years, minimum 2 years imprisonment, at least in Vermont. The way that's the dividing line between felonies and misdemeanors.
Great.
All right.
We can get going.
All right.
Thank you.
Bet. So detail now, dive into the detail a little bit. Let's start with the first piece. Remember I mentioned there are these different concepts going on. The safe storage is the one that comes up first. Secure storage, I should say. Now this is a general prohibition. Actually, I should move that down a little bit so we can have the right language in front of ourselves. Let's get all this on one page. That would be perfect. So you've got essentially a general prohibition on if you're a person who keeps firearms in a premises that's under your custody or control. That's one thing, right? These sort of initial elements that apply before the safe storage requirement applies. It doesn't apply in all situations, right? It only applies if A, you're a person who keeps firearms in a premises that's under your custody or control. And B, you know or reasonably should know that a child or another prohibited person is likely to gain access to the firearm. See that? So that's lines basically 16 through 19 on that top page. So that's kind of your initial threshold criteria. So that's when the safe storage requirement kicks in. You're one of these persons who has firearms in the property that's under your custody control. And number two, I think I said B the first time I said that. 2B, you also know or reasonably should know. I'll just point out from a legal perspective, since you know, knowing and reasonably should knowing are legal terms. Knowing refers to actual knowledge, and reasonably should know is what's known as constructive knowledge. That based on all the facts, you should have known. Based on all the indicators, that a reasonable person would understand in those circumstances, you should know.
Yeah.
So, pausing for a moment.
Yep, I think
Okay.
good.
All right, so child is, we'll see this when we go through the definitions later, just to point, definitions later, but just to let you know, the child is a person under 18. You see that in line 18. And a prohibited person means a person who's prohibited by either state or federal law or a court order from possessing a firearm. So that's generally referred to as a prohibited person when it comes to firearms. And those are the kind of things that ideally come up on the background check, because NICS maintains this database of prohibited people. All right, so if you're one of those, if you fit into those two criteria, then the safe storage requirement kicks in. So the obvious questions are, right, well, what is a safe storage requirement if that kicks in? Two main pieces to it right here. First of all, the firearm has to be separate from ammunition, right? So it can't be loaded. Got to be separate from the ammunition. And number two, or B, as we use in the actual text, has to be, besides being unloaded, it has to be in a locked container. Now, this is an either or. So it could be in a locked container. That's one option. Or option two is, or equipped with a tamper-resistant mechanical lock or other safety device that's properly engaged, so as to render the firearm inoperable by any person, other than the owner or user. Okay, so you got two options there. You could either keep it in a lock safe, or you could have some kind of a tamper-resistant lock or other safety device on it. But either way, would basically satisfy the requirements for safe storage.
Okay, Leslie?
So just so I understand, it could be loaded in the locked container?
I don't read it that way.
Okay.
And I think the answer to that is
No.
not supposed to be.
Okay.
Right. I asked myself that same question. but yeah.
Alan? Bobby?
Well, my question is, what the definition of the container? For example, let's say I live in a trailer and I lock my door and the gun is in there. No way can somebody get in there without breaking a lock. So does that house trailer count as the locked container?
Interesting question. Let's look at the definition, because I hadn't thought of that particular question. There is a definition section at the end, so hope you're okay with me speeding this through.
Yep.
Yeah, let's look.
All right, line 11 and 12, page 5. A box, case, chest, locker, safe, or other similar receptacle. So I'm gonna say, doesn't sound like it counts.
Okay,
Um,
so house is not enough of a box.
Right.
Not a receptacle, I guess.
I
Right,
want to ask.
Or is it?
good question though.
Sorry, I'm going to take chair privilege and jump in front of everyone. So on that question,
Yeah.
going back to the first part of your thing, what if I live in a mobile home by myself and there is no child or anyone else living with me? Do I have to secure my firearm?
I would say it generally would depend. Generally speaking, no. But let's say you regularly watch just picking the person who lives by themselves. Let's say their nieces and nephews regularly come over every Saturday afternoon. In that case,
Yes.
it might apply.
Yes,
you know?
okay. But if I'm home and,
Right.
right, okay, so we had Brian.
No, well, my question is basically the same thing.
Okay,
My guns are locked right now in my house. Okay, if I have a loaded gun there, I'm still within the law. You can have a loaded gun in the state of Vermont.
You can, it depends, it all depends on as the chair was saying, kind of what the circumstances are with other people that live at your
My
house.
house is locked. Nobody
Right.
lives there but me.
Oh, yeah, you're fine then. Yep.
Brian?
Or you would be fine. It's not the law yet.
Okay, yeah, no, that's fine now.
So I have a few questions and maybe I could just ask them and then you could decide how to answer them.
Sure.
Because I was looking ahead too, because sometimes the answer's coming, but like, I'm struggling with like how you can defend yourself if your gun has to be locked and stored at all times if someone breaks in your house. So I don't know if you can explain how in the law here it allows you to still have a weapon for self-defense. Or like how a person would be expected to defend themselves if their ammunition stored separately from their gun and everything's locked and like someone suddenly is breaking into your house. I'm wondering how this affects duty to warn and mandated reporting laws for providers, because as a healthcare provider, like, would I then be having to tell on people for not having their guns locked and not, which then is that going to make people not tell their healthcare providers the truth about what's happening, and what impact might that have on prevention of suicide? Because if people aren't telling you the truth because they're afraid of the law, then you can't help them. So that's something I'm just wondering how that plays into this, and we may need more testimony to figure that out. And then the other thing was, this is kind of random, but like, Art was talking about someone going to Dick's, I think you said.
Yeah.
And buying a gun, yeah. This might be a sportsman question for later, but like, how often do people just come to Vermont and buy a gun to go hunting? Because I would think if you're going on a hunting trip, you've got your stuff already. So I've just, that maybe we can get to that later. So I don't know, those were 3 questions I had that had accumulated, but I feel like 2 of them you might be able to answer now. The duty of the warrant mandated reporting one, and the one about how do we defend ourselves if our guns stored separately from ammunition and locked in an emergency.
I can't answer the duty to warn one. I'm not familiar with that. We'd probably have to ask Jen or someone else for a little more information on the mandated reporter stuff. The first one on the self-defense piece, though, going back to that one, I would turn to the exception, because there is an exception on page 2 for a firearm that's carried by or under control of the owner or another lawfully authorized user. So if the person's carrying, well, and I read under control as, obviously that is a term that's could be read different ways. I read it as, it doesn't have to be on your person. So if you've got the firearm, say on your nightstand next to your bed, that sort of thing, that reads to me as under your control, that's within your wingspan, Now, if you're asleep, that might be different, because then it's not really under your control. Maybe you do have to store it separately when you go to bed. I don't know. But I would say that as a waking person who's awake, you have the opportunity under that exception to be able to have a firearm on your person or within your wingspan for self-defense in an emergency situation. That maybe is only a partial answer, but probably.
Thinking about it is stressful.
Yeah.
And then I just want to add in on that. But if you're a sleeping person and you're sleeping in your home by yourself with the doors locked, you would be exempt as well because of the first part of the definition.
Yes, even if the doors weren't locked. If you're there by yourself, you don't fall under the safe storage requirement. That's right. Yeah.
In full disclosure, I did buy my 308 from Dick's. As far as your question, good question, Brian, about needing to use it and having it locked up. I currently have a cable lock on both my handgun and my rifle. And my handgun is separate from my ammo in a vault. The vault does have a fingerprint function, so it's easy to access quickly. And the same could be done with ammo. So you could have a relatively short period of time from when you know that you need to defend yourself and when you are capable of doing it with your firearm. The question I have is about what we're asking for as far as safe storage. And I recognize that there's a legal definition further down. But locked container seems pretty generic to me. And I'm struggling with, I think we should be more clear about the specifications for such a locked container, which I think there should be some tighter specifications. The container, that would render the container almost impossible for someone else to get into. But I also don't want to reduce access for people wanting to do the right thing and get a storage container. I don't want to price it out of accessibility for people to have a safe container. So I think that's for a discussion further on, but I just want to get it on the table. And I don't expect you to answer that, Eric.
Right. No.
It's a concern I have, and I hope we can talk about it and get more testimony about that later.
Okay. Made a note. Okay, can we keep going?
Sure. So we would kind of already just started getting into what the exceptions are. You see that we just mentioned the firearm if it's under the person's control or if it's being carried. So that's an exception. That means that it would not be a violation of the statute, in other words. So the person couldn't be charged if they're carrying the firearm in that way. And it doesn't have to be stored. The storage requirements don't apply. If a subdivision B there, if a child or a prohibited person, remember that's a person who's legally prohibited from possessing a firearm, they gain access to it as a result of an illegal entry. In other words, if they end up having it because they break into the house and get it, well, then you can't be charged with a safe storage violation. And similarly, if you have a situation where in subdivision C, where the firearm has to be used in self-defense by the child or a prohibited person, there's some sort of a threatening situation that develops where the child has to actually use the firearm in self-defense, then again, the person who stored it isn't going to be charged criminally if that sort of a situation developed. We have essentially a tiered system of penalties here. That's what's happening in subsection B. When I say tiered, it's basically increases depending on whether or not you've got some aggravating factors. So 3 different possible penalties depending on whether or not any of these aggravating factors are present. First one, straight $100 fine, assuming it's just a storage violation, right? Nothing else happens. One way or another, law enforcement becomes aware that the storage requirements were not complied with, $100 fine. Subdivision 2, though, well, what if something more than that happens? What if it wasn't stored properly and the child or the prohibited person gains access to it and uses it to commit a crime or causes it to be fired or displays it in a threatening manner? So any one of those aggravating circumstances happens, then it's stepped up, becomes a 1-year misdemeanor, 1 year, $1,000. Now, what if not only does the child or prohibited person gain access to it, but they use it to either kill somebody or to cause serious bodily injury to a person? In that situation, it becomes a felony. Then it's a $5,000 felony. So everybody see it's a tiered penalty system, and it increases depending on.
Can I just want to clarify something because I read it kind of flipped for me. So I just want to make sure I understand it. So a person who violates subsection A shall be fined not more than $100. So that's its own thing.
Yep.
Then if a child or prohibited person gains access to the firearm and uses it in the commission of a crime, causes it to discharge or displays it in a threatening manner, you could be fined $1,000 or imprisoned not more than 1 year.
Mm-hmm.
And then, or if a child or prohibited person gains access and causes death or seriously bodily injury, it's not fined more than $5,000, not imprisoned not more than 5 years, or both. So those are 3 distinct things, correct?
Exactly.
Okay.
And thank you you may not have done it intentionally, but you noted a typo.
Oh, I did not do that intentionally.
Line 16, there should be an or after the word manner.
Topper?
Number 3. Are there laws on the books now? If a person shoots somebody else and kills them, are there laws on the book now?
Yes.
In terms of what that should be?
Yep.
So how would this affect those?
Well, this is a very specific, it wouldn't affect it in the sense that one might be able to be charged with a homicide in addition to this, if that's kind of what you're getting
That
at.
was my question.
Yes. They could be charged with both counts. Could be one count of, second-degree murder or involuntary manslaughter, depending on the circumstances of what happened. Could be one count of that and one count of violating if it were called the secure firearm storage statute. So it could be, would be generally, how it is potentially charged and how it actually charged are 2 different things. It could potentially be charged with both. In practice, usually prosecutor agrees on one, tends to be more often, but.
Wouldn't 2 separate people now be charged instead of just one? I mean, if in the case of if a child accesses it and commits manslaughter, then the child would be charged with manslaughter. but the person whose firearm it was that did not store it securely in the presence of this child would then be charged with this. So you'd be two different people being charged, not the same person stacked charges, right?
The vast majority of times, that's true. Absolutely. There can occasionally be the case where someone can be charged with involuntary manslaughter, for example, by conduct that's so egregious that, I'm not going to try and describe what it might be, but it's possible that adult providing access to a firearm to a child, not necessarily just failing to meet the storage requirements, but there are ways in which it could conceivably be charged for involuntary. But for the most part, I think probably 95% of the time, you're exactly right, that the criminal offender would be two different people. The child who, used the firearm and the adult who didn't store it properly.
Or prohibited person.
Yes, right, thank you.
And again, I want to keep bringing this back to our lens, which is healthcare and suicide prevention. And so today, the laws do not allow if I, as a homeowner and a parent, don't secure my gun today, and I know there's no, secure laws right now, but I just have my gun out and my child commits suicide using that gun, I cannot be charged for any negligence in that death today.
Not criminally. That's what this is, right? Not criminally.
Okay. Any other questions? Okay.
Well, I guess I want to, causes it to discharge. I'll just set up a scenario. My son finds a way to get the gun out of my house, out of my gun safe, and goes out and goes to the target range where I brought him tons of times and discharges that gun. How does that work?
Well, you had it stored.
You had it stored.
Yeah, but it doesn't matter. You get into it and he got it.
So,
No,
so Eric, can you confirm if in his scenario, he has the gun properly stored, someone breaks in and steals the gun and takes it to a range, could the person who was stored the gun properly be charged?
No, as long as you stored it properly in the way that the statute requires it, you're not going to be charged, particularly under subdivision B there specifically. So somebody breaks in and takes it.
No, I didn't say break in.
Oh,
I said my son
right.
who lives in the house.
Yeah.
Okay, so if it's in a gun safe and I've stored it properly without the ammunition in the gun safe.
Yep.
Some other place, then it can't be charged.
Correct.
Now, in the definitions, it says box and container and that kind of stuff.
Right.
I'm concerned about the term box, what that means. Is it a box that's nailed together with a combination lock on it? Is it a box that's screwed together? Or what kind of a box are we talking about? A metal box? Because if it's a box that's nailed or screwed, it can be taken apart and the gun can come out.
That's what I was asking.
Yeah, I know you were, but now when I get into this, causing it to discharge. I've stored it properly in the box. My son takes the box apart, gets the gun and goes to the range where he always goes.
I tend to view it as if you have met the definition of proper storage, then you're okay. And I think you're right that the word box is going to have to be read into the plain language of the term. It could be that, it's a box. Some boxes are perhaps more secure than others. That's probably true. But if you meet that, if you look at the, very initial language in the proposed statute, this applies unless you keep it separate from the ammunition and stored in a locked container or equipped. So if you've done those things, you're not criminally liable. But there may be some some argument that could happen down the line as to whether or not a box was a good enough box, that's possible.
Alyssa?
Wouldn't the tamper resistant be the key part of that? I mean, it doesn't say impossible to tamper with. It just says it has to be stored and it has to be tamper resistant. If you have a particularly crafty 16-year-olds who can, I mean, it doesn't say it has to be absolutely impenetrable.
Right.
You just knowingly need to put it someplace that,
Generally speaking,
I kind of envision it as the same as like, they have temper resistant medication bottles. So kids aren't supposed, but like my child can get into one of those things, right? So I think temper resistant is a good point, but we will come back to that language.
Okay, I
Because we have
think
some
we need
concerns.
to.
Yep, we will.
Because case is the same thing.
Yep.
I interpret case as the gun case.
yeah, that's how I interpret it too.
Maury?
Still on this subject, and I think we do need to have someone come in and testify about safe storage materials there. And there are, the Underwriter Laboratory has burglar ratings for residential security containers. I don't know, maybe someone in this room can help us find someone to testify about specifications of actual devices. For example, in this National Safe House website I'm looking at, door construction is important. Look for a gun safe with at least a 1/4 inch of solid plate steel, et
So Maury,
cetera,
I'm going to
et
ask
cetera.
that we get through here and come back to this topic.
I don't need to come back to it
Okay.
anymore today. I'm
Okay.
just
Yep.
underlining that I think this is a really important point for us. And I think we definitely do need more testimony on it because there are, I think, some national criteria that we can perhaps use.
Right, let's keep going.
Sure. So we're now moving on. We just went through the penalty piece. So now we're moving on to, there's a separate subsection C, starts on the bottom of page 2, that has to do with charging discretion. So this essentially is saying to state's attorneys out there, if a person violates this statute, in other words, if they've stored it improperly, right? They haven't complied with the storage requirements. If it's stored improperly and that person who stored it improperly is the parent or guardian of a child who then uses it in an unintentional self-inflicted shooting that causes death or serious injury, then that fact can be considered by the state's attorney. It's really more of a highlighting piece. And it's certainly not the case, I don't think, that a state's attorney wouldn't take that into consideration. But this really highlights it and emphasizes for the state's attorneys, hey, if that's the way that the facts unfolded, then take that into consideration when you're deciding whether or not to charge that person with a storage violation. So that's what's going on.
Yep.
How would that be determined that a person didn't have the weapon stored or the ammunition separated? How would that be found? I wonder.
Well, if you assume that there was a shooting involved, because it says,
Sure, that happened.
right. So probably, or at least very possibly, the police were there because of the shooting.
Okay.
So law enforcement might have been on the scene, could have been self-reported. Could have been the person, they might say, whether it's in speaking with law enforcement or speaking with other people, could have been witnesses, other people in the house who knew, who saw. So those are the types of facts. You're right that it might not necessarily be known. It would depend on whether or not there was other people.
But the police are going to ask questions like, show me your weapon storage box, right?
If there had been a shooting, they might.
If there's a shooting like this, in order to meet the requirement of this section, they would have to ask those questions, be shown a container that would hold the weapon as proof that there was one or wasn't one.
Yeah, I think if there was a shooting, there's in all likelihood going to be a law enforcement investigation, so they probably would ask those kind of questions. If this were law.
Right. I'm assuming this is law.
Yeah.
So there'll be invasion, but it would be an intrusion into the property of the person that had the gun to find out.
Well, if there was a shooting, there'd be an investigation.
There'd be an investigation anyway, but you'd investigate the area, but now, you know, they couldn't investigate further into the house to find this box. And I just trying to get it clear in my mind, that's all.
Sure.
Before we go on to the information distribution, do you know how many states have secure storage laws in place today?
Yeah, I've looked into that and they, you know, the types that different states have vary somewhat. But I'd say you could roughly say in the low 20s, you know, 20, 25 in that neighborhood have different types of some sort of secure storage, safe storage. Sometimes they're called CAP laws, child access protection. That's another sort of phrase that's kind of used for them, and they're not all exactly the same, but if you were speaking generally, I'd say that's a good number.
And my understanding is New Hampshire has.
New Hampshire's got one, yeah.
Do you know if New York or?
Don't, I know Massachusetts and Connecticut have them. Those happen to be two that I looked at. I'm not sure about New York.
Can I answer that?
Sure.
New York has one, Maine has one, Massachusetts has one, New Hampshire has one, Connecticut, of course, has one. Every New England state has one, except for Vermont.
Okay, thank you. Okay, information distribution.
Yes, and I kind of touched on this at the beginning. This was sort of concept number 2, big picture concept. This is requiring some information to be distributed by various entities to different people. The first one, subdivision 1 on page, actually subdivisions 1, 2, and 3 all kind of go together. This is about information that has to be posted at FFLs. Remember I mentioned that federally licensed firearm licensees, federal firearm licensees, sorry. And these are dealers in firearms that have to be licensed by the federal government if you are in the course of business, if you sell firearms as part of your business. And these folks are going to have to do a couple of things with respect to firearms storage and safety information. In the first paragraph there, say line 16 to 13, just realized I'm on the wrong page, or wrong part, right, say line to 16, 13. So at their location, they're going to have to post a sign. That's line 6 to 7, right? And we'll get to what the sign has to say in a moment, but there's some details here about how big the sign has to be, where it has to be, you know, it can be easily viewed, line 9s and 10s by customers, has to be lit, where the transfer occurs, you know, in other words, with their place of business, where it is, it's got to be posted there. Then you'll see there's some size requirements for the sign in subdivision 2, lines 14 to 17. The way it's written here, it's 8.5 by 11, which I think is more or less this, right? And some requirements that the text be at least a certain size. And then what does it say? Again, some provisions about firearm safety and its potential impact on suicide. I can read that if you like, but I'm sure once you sort of look at it for a moment, you'll see exactly what it has to say exactly right there. There's warning in block caps about access to a firearm in the home, significantly increasing the risk of suicide, death during domestic violence disputes, and unintentional deaths of children, household members, and others. Then there's a warning that if you're experiencing distress or depression, it's called the suicide or crisis hotline. This is all still part of the text. We're still in the text here, 3 to 7, so it goes on. Vermont law talks about what the legal requirements are, that secure storage is required, and that if you don't securely store your firearms, you could have criminal prosecution. And then lastly, line 8, pointing out that this is posted as part of the legal requirements, just to make sure that number is right. So there's another typo. That should be 4,024, not 4,023. Minor detail, but that should be correct, especially if there's actually a sign.
So Eric, to be clear, the warning that will have to be posted starts on page 3, row 18, and goes through page 4, row 7, line 7.
Yes.
Line 8, really.
Line 8, yep, exactly.
Okay.
Yep. Now, we got a couple more elements of this information distribution. This next one, paragraph 3, has to do with the Department of Health. They, in consultation with the state police, has to develop detailed information regarding firearm safety and provide it free of cost to the same dealers that I just mentioned. So they have to develop the information, give it to dealers And then dealers, you look at the very last line, lines 15 to 16, dealers have to distribute that information to all firearms purchasers. So if you think about it, that means there's two ways in which the dealer is sort of disseminating information. One is the poster, and the second is they got to hand this information out that Department of Health and state police developed. That's number 3. Seems like number 2, but. Number 4, so this is another thing that also is a requirement of the Department of Health, this time in conjunction with the Agency of Education. They also have to develop this detailed info on firearm safety and provide it free of cost to students and parents. So there's another avenue that information has to be disseminated. There's some details about what has to be in it, risks associated with firearms, suicide prevention resources, the secure storage stuff that we've just been talking about all has to be in there. And this has to be given out annually. You'll see now over on to page 5, lines 1 to 4. There has to be an annual distribution of a pamphlet with this information, and it also has to be posted on the school district's webpage.
Does the information that's developed by whatever entity,
Yeah.
does it all have to be the same?
I would say not necessarily. No, I think.
My question then is, why not? Why wouldn't it be the same?
I think you're right that it could be. But I thought you were sort of asking, do they have to make it identical? They're not required to, but I think, for example, if you're the Department of Health, the Department of Health, and you're involved in both of these information pieces, I don't work for them, but if I did, I would certainly, make my workload more efficient and use anything that could qualify for both. You probably would use it for both.
And we could require.
Yeah.
You certainly could.
And my other question along those lines is, why is Spanish the only language, other language that it has to be in?
That's a good point. It was just all I did was pull that from another state statute, but there's no real rhyme or reason to that. So, you could expand it, strike it. I don't think there's a right or wrong to that, other than as a policy preference, what the committee wanted to do.
Daisy?
Thank you for that question, Topper. It was mine too. I'd like to revisit that when we have committee discussion on this, the languages. And then also flag that on page 1, line 8, refers to this section that we've just gone through about basically education. But the purpose of it is really just to require information to be distributed. I'd like the purpose to be to educate the public, not just to simply distribute information. So I'm just flagging that for committee discussion later. This does distribute information, but if there's a way to kind of have a conversation at some point about.
I think, to your point, absolutely, I completely agree. I think the including risks associated with firearms, I think that's more of the education piece.
It's there. My concern is I have seen resources like this go up on a website and people don't access the website, or it's so buried in the website that people only might stumble upon it. Or these materials are at the store when people purchase a firearm, but it ends up on the floorboard of their truck, or they don't, it gets thrown in the trash with the bag, or, people don't implement the learning. And if we're going to go this far, we should go farther to implement training and hands-on education. That's a question. It's a much bigger conversation, but I love this, but my question is, why don't we deserve to actually educate people rather than just disseminate materials?
So that will be in the second bill that we take up. Yeah, and I'm sorry we don't have that introduced yet, that it hasn't made it through the process. So this is specific to the FFLs, and then there's going to be a much broader conversation on how we get education into the community.
And is that education going to include the FFLs, or is it going to be a standalone?
We can talk about that when we do that as well.
Cool.
Yeah. And I know Brian actually had some thoughts on educating FFLs on warning signs. So we can talk about that in a little bit. So,
Thank you.
any other questions on the information distribution? All right.
All right, brings us to big picture topic number 3. And we are now moving on to the ERPO law. Remember, that is an extreme risk protection order. And that is an existing provision of law that was passed in 2018. And as I mentioned earlier, this allows state's attorney or attorney general to bring a petition in the civil division of the Superior Court, trying to get an order from the court, known as an ERPO, that prohibits a person from possessing, receiving, purchasing a dangerous weapon. And it has to be based on a finding by the court. So the court has to make a finding that there's clear and convincing evidence that there's an extreme risk of the person causing harm to themselves or another person through use of this dangerous weapon. See that? So there has to be a finding by the court. There's a petition by the Attorney General, the state's attorney. Court makes that finding, and then it can then issue an order that prohibits the person from possessing a dangerous weapon for either a period of 14 days or 6 months, depending on where the case is at. But those are your maximum amounts for the 2 different types of orders.
Leslie?
So we had testimony from Dr. Swanson, and I don't recall where he was from, but he was very impressive about ERPO. And one thing that he mentioned, he said, can be initiated by law enforcement or family/friends. And your language doesn't include friends. And I was wondering about that.
Well, just a friend, I think you're right, although it all depends. We'll look at in a moment, but it brings me right to what is a household member.
Okay.
Because we'll look at that and see if it addresses some of what you're thinking about, but probably not entirely, but maybe
Yeah,
partially.
I don't imagine, because
Yeah.
I'm thinking about, your best friend
Right.
who's worried about you.
Right,
Do they have standing? And
Yeah.
that's what I would hope to include.
sure, yeah.
Okay.
So that is a nice segue to who these folks are who can bring the petition under the proposal. So as I remember earlier, I mentioned that this was based, when I originally drafted it, on the existing RFA provision in Vermont law, RFAs. So let's look at that for a moment, because you'll see right there, line 19, page 5, when the definition says household member has the same meaning as in 15 VSA 1101. Well, that's the RFA statute. That's the exact
Relief from abuse
cross-reference for relief from abuse order that I used as a model when I drafted this. So let's look at it and see, well, all right, how is household member defined? And before we do that, I should mention that, remember it says, for a second, household member is defined, but what's done here is that it's not just household member who is provided the standing to bring one of these suits. It's a family member as well, right? Family or household member. Family member, interestingly, is not defined in the underlying RFA statute. It uses the same term, family member, household member can bring the suit. There's no definition though. So the Vermont Supreme Court did define it, because that, as you would expect, that came up in litigation. Somebody, I think it was not somebody's brother-in-law, but the brother of a brother-in-law wanted to bring a petition. And the court had to say, well, is that a family member? And the court said, no, it said, well, when the legislature doesn't define a term, we have to look at what the plain ordinary meaning is, right? And it turned to Black's Law Dictionary, a well-known law dictionary among law students, and you confirm me there, Chris. And said, all right, what's the family definition there? Family member. The conclusion it reached was someone related by blood, affinity, or law. So it's a blood relation. Affinity is an in-law, right? So it's blood, affinity, or law, some legal. So if the law has said that you have a family connection. And so the court said, no, a brother of a brother-in-law is not a brother-in-law. So that person could not bring the suit. That didn't qualify as a family member in that case. But for your purposes here, that's obviously, so the court has laid down that definition in law as to what it means. So although family member is not defined right here in the statute, pretty clear, the exact same term that's used in the RFA statute that this was based on, I'm quite confident that that's the same definition they would use if it ever came up again, blood, affinity, or law. So that's your family member piece. Doesn't cover your household member piece, so how did that actually is defined in statute, and that has been the subject of much ongoing discussion both in this legislature and in Congress. So here it is. You'll see household members is defined, subdivision 2. This is the RFA statute that I mentioned. Means persons who, for any period of time, are living or have lived together. So that's one possibility. You're living together or have lived together. I read that too as possible. Doesn't have to be a romantic relationship. Could be roommates, right?
20 years ago.
That's right. Good point. Or have lived together. Yeah. Are sharing or have shared occupancy of a dwelling. Are engaged in or have engaged in a sexual relationship, or minors or adults who are dating or who have dated. So that includes all those people. And then it sort of goes on to say, well, what does dating mean? Dating means a social relationship of a romantic nature, factors the court may consider when determining whether that dating relationship exists or existed include, and it lists some evidentiary factors that might go to the court finding, well, is this really a dating relationship or was it not? Depends on the nature of the relationship, how long it lasted, frequency of interaction between the parties, and the length of time since it was terminated. So that's the current definition. So anyone under current law, that's current law. So anyone of a person who falls within that definition of a household member could bring an a petition for a relief from abuse order, right? If they think that someone who they have that kind of connection to, say, you know what I mean? This was their former roommate, their former dating partner, whatever it may be, their current roommate, current dating partner, if they fall within that definition, they can bring a petition for a relief from abuse order. So the proposal is same definition applies in the ERPO context. So we'll go back to.
Can I just write that? I would just want to write that down. Where are we in statute on that?
Are we what? Sorry.
What's the?
Yeah, it's 15, Title 15 VSA. Yep.
Chapter 21.
Yeah, and sections 1101.
Thank you.
Yep.
It's in here too.
Okay. Pepper?
Just out of curiosity, is godparent, is that defined anywhere?
What's, oh God.
I don't, that's a good question. I don't know the answer as to whether a godparent.
That's why I asked the question.
Yeah.
Godparents, if let's say the mother and father.
Right.
An individual.
Yep.
Were deceased, godparent takes over.
Mm-hmm.
Then they would be legal guardians.
Yeah, if they were a legal guardian, I would say they would be covered by or law. But I was thinking of your first question, even before you got to that point, just as an example, my wife is the godmother of a couple of friends of her kids.
Yeah.
I don't know if it should be covered or not.
You could bring them into the family.
Right. And if we did legally, then they'd be covered. Or they'd be household if they lived there, or if they were adopted, or a guardian, as you mentioned. Probably would depend upon the facts, but it's an interesting question.
Well, you could be 18 too. You could be over 18.
Hmm?
Still a godparent. I have a personal thing with that one. When a kid came into my house, stayed there. I never adopted or did anything.
But he'd be a household.
But they'd be a household member.
Yeah, that's true. Split cemetery.
It's hard to keep it all straight. All right, back to the language.
Yeah, so it really, for this section of just, that's really it for this piece. I mean, this is, the idea is, thank you. To, as I mentioned, you're expanding the universe of people that can bring a petition to the court for one of these extreme protection orders. You know, right now it's the Attorney General, the state's attorney. The proposal is to expand that to include a family or household member.
Alyssa?
Didn't we do something last year extending to physicians or medical? Why is that not in this statute?
This wasn't, the extension was not to allow them to petition.
Okay.
It was to allow them to provide law enforcement.
Okay.
With information that they were concerned that they couldn't because of HIPAA.
Yep, thank you.
And, yeah.
Art?
How long a process is this when somebody petitions to, I mean, is an investigation done or what is done actually on the ground for something like that?
Right. So you have two different sort of motions or ways in which a person could bring one of these actions. And one of them, you'll see right there, section 5, the title, Emergency Relief, Temporary Ex parte Order. These move along much faster than the 6-month final order, which could take longer, require more evidence to be developed, as you were indicating. As with RFAs, these emergency relief proceedings are prioritized by the court because the assumption is that there's somebody who's potentially in danger. And they can be brought ex parte, I don't know if you know that legal term. That means that if you're the person who's alleging, in the RFA context, it could be the victim. In this context, could be, say, the parent, the roommate, whoever it is that thinks that the other person poses a danger. Ex parte means essentially alone, by yourself. You don't need to give notice to the other party. Ordinarily, when you're doing a court proceeding, for due process purposes, you have to provide notice to the other person so they can come in and defend themselves if they so choose. Ex parte, you don't have to do that. You can go right into court immediately, and because of due process constitutional requirements, that's why this ex parte order can only last 14 days. Because by the end of the 14-day period, the other person has to be given an opportunity to come into court, defend themselves, or argue differently.
Okay, so this is only for a 14-day period.
The first one. There's two. The first one is only 14 days. Yes, that's the emergency one. They can do it by themselves. Then after that, if they so choose, they can try and get the final order. That one takes longer. That one, there's going to be more evidence developed. A person can, bring their own evidence, could dispute it. And those can last a maximum of 6 months. The first one,
how much?
6 months? 6 months, yeah.
And that's a judge's decision that does that?
Yes, yeah.
Okay, so.
And that's current law. We're just adding that the
Right,
state and people who will, okay.
Exactly.
Yep. Leslie?
So it's by definition, I'm just looking for the 14-day, but I'm not seeing written out. Did I miss it or?
No,
That's so that,
every piece of the underlying statute isn't reprinted here.
okay,
It's
so
not-
that comes
yeah.
from 13 VSA, blah, blah. Is that what you're saying?
The 14 days, you mean?
Yeah.
Yes, exactly. It's
Okay,
in
got it.
4054, but it's not in your
I
language in front
understand.
of you. Yeah.
It's where the asterisks.
Yeah.
Yes, over on line 3, page 7. Yeah. We try and save paper with those
Of course.
sometimes.
Go ahead.
A question on how bad does someone's behavior have to be to cause it to go into effect? Can, somebody be getting nervous about, can you say, well, gee, I worry about my child or my friend or my whatever, or can't be friend, I guess, but, what do judges look at here, I guess?
No, it's a good question. And I think just to illustrate, I believe in the statute, and this is the firearms chapter, which is where the ERPO law is. So I'm just kind of cruising down to try and find, here we are, ERPOs, right? And so, all right. So here we are. So just sort of this for illustrative purposes, some of the things that will go into that decision. Extreme risk of harm to others may be shown by establishing that they've inflicted or attempted to inflict bodily harm on another person. That by their threats or actions, they placed others in reasonable fear of physical harm to themselves. They presented a danger to persons in your care. Extreme risk of harm to yourself may be shown by that they threatened or attempted suicide or other serious bodily harm. So those are the kind of factors that will kind of go into the court's decision.
Ellen?
I know up home, Franklin County, a lot of times it's a grudge match between spouses splitting up. I feel threatened about my life. They come and get your weapons, they take them, they put them in storage, which nobody seems to know where. And it's months, not 6 months, it's longer. And then they get a bill for storage of their weapons, and there was no case. So there's still some flaws in that. That could go on for months.
That's an issue in that neck of the woods then that would need to be worked out with the state's attorney's office and wherever it may be. That's
Anybody, you know,
right.
had a girlfriend once and threatened,
Right.
no.
I mean, it's, you know, the
Seems to
way,
be a larger issue.
yeah, that
I
seems
know.
to be outside of what the law is stated to be. Yeah. All right, let's keep going.
So, yeah, unless there's any further questions about the ERPO piece, I think we've kind of covered how it works, right? You can see all the language changes are just the exact same thing, which is just adding family or household member every time it's needed to be added, so that it's clear that a family or household member can bring one of these petitions as well. So that brings us to the last piece, which is the waiting period. Again, we sort of talked about this a little bit at the beginning as well. Basically requires a 72-hour waiting period after the completion of the background check. Remember, we talked about that. So the background check could be finished at different times depending on what the results were. But in most cases, if the background check clears, that's when you're 72. Actually, in all cases where the background check clears, but in most cases, the background check does clear. That's what I meant to say. And when that happens, the 72-hour clock starts ticking right then. And that applies, you'll see, and there's really two places that this is mentioned. It's really clarified on page 8, subsection C, lines 4 and 5. See, the section does not apply to a firearms transfer that does not require a background check. So if this is only going to apply, this waiting period, if a background check also applies. So that sort of begs the question, all right, well, when does a background check not apply, right? So what are the exceptions to the background check statute? So I'm switching right over to this, which was also passed in 2018, I believe. There's the background check provision in Title 13. You'll see the definition of immediate family member there. There's a reason for that, because transfers between immediate family members are not subject to the background check requirement. And that was also the subject, you may recall, if you were here a few years ago, long debate about which relations should be included in the immediate family members who so that they're exempted from the background check requirement. The current law reads spouse, parent, step-parent, child, stepchild, sibling, step-sibling, grandparent, step-grandparent, grandchild, step-grandchild, great-grandparent, step-great-grandparent, great-grandchild, and step-great-grandchild. So if you fall into one of those categories, and get down to the exceptions here. There we are, subsection F. This section shall not apply. So background check not required to law enforcement transfers, military transfers, number 2. Number 3, immediate family member, and subdivision 4. This is the emergency situation exception. So if there's an emergency situation when someone really needs to be handed a firearm in order to defend themselves or defend somebody else, then obviously you don't want in that situation to have the person trying to go get a background check. So there's a kind of you might think of it as an emergency circumstances exception. So these all apply here. Therefore, they also apply here to the waiting period by virtue of what you say in subsection C. It doesn't require, if the transfer doesn't require a background check, doesn't require the waiting period either. So generally speaking, though, the violation lines 1 through 3, it's a 1-year misdemeanor. So if you do transfer the firearm to another person without waiting the 72 hours, then you're subject to this misdemeanor penalty.
Leslie?
I'm trying to get sort of combine these two things through the lens of suicide, because that's what we're talking about. So let's say someone was considering doing harm to themselves and they had a firearm in their possession, they could just hand it over to their relative and that would be a good solution. Is that what I'm understanding? That is
I may have missed a little bit on
well,
that.
it's
Sorry about
probably
that.
not really logical, but I'm just thinking about someone who's in the throes of impulsive anxiety, moment. and there's a firearm in the world, they could just transfer it over to their immediate family, and that's legit. That's what we're talking about. That would work, and I'm just trying to
Yeah.
understand this
I think
statute in the world
yeah.
of suicide.
Yeah, I think for two reasons. Family member, because the family member exception, as well as the emergency circumstances exception.
Yeah, because the emergency, that was what, I had it in a flipped mind, because you were saying emergency circumstances was one of imminent harm from, let's say, an intruder. But it also would apply emergency circumstances to yourself, I guess. I'm not sure that makes sense.
No, it does. It's an interesting language question, though. Yeah, I think it would apply. Yep, even if it's harm to self, the way it's written. I don't think it necessarily, I remember, because that language was added on the Senate floor, I remember it quite well. And it was at that time being thought of in more of a other person sense, although now that I think of it, I think both fact patterns were brought up.
Okay.
It could be another person or it could be harm to self.
Okay.
That was thought of as a possibility. Saying, I'm going to give this to somebody else for a period because I'm feeling unwell. I don't want to harm myself. I think that was
Would it be
discussed.
that I'm going to take it from you because you're frightening me? That would not be, would that qualify?
Well, that would be if the person doesn't want to give it up, that's the relief from abuse order.
Yeah, but then you have to go to court. I'm just in the moment. I'm just trying to figure out how to.
Yeah, tougher.
Can you transfer a weapon to a person under 21?
You cannot sell a person, a weapon, sorry, a
I
firearm.
can't sell
Yes, but you can transfer. You can
it. Can
gift it.
transfer?
You can gift it. Or,
Okay, is there any kind of in law now that says you have to have a piece of paper or anything like that? When you, do I have to have a note saying I'm transferring this to? Or
Like
you
your
just say,
car.
"Hey, see you later"?
Documentation to go with the transfer to a family
Right.
member.
Yeah.
that's an interesting question. You mean assuming that the transfer doesn't require a background check
Right.
because it's a family member.
Right.
I think all firearms have to have a serial number, for example. But I don't know, I might defer to someone who might have more expertise in that area than I have, for example.
Only if you want to answer.
Am I allowed to?
Yep, please state your name for the record.
Transfer.
Chris, can you state your name for the record first?
Chris
Just
Bradley, Federation of Sportsmen's Clubs. Transfer usually suggests a change in ownership. So for example, this gentleman here wanted to borrow my hunting rifle. As long as I knew him and there was no compelling reason why I thought he would be a bad person, I can loan him that gun. So in your situation, you're not encumbered. You can essentially say, can you just hold this for me? I'm not transferring it to you. You just hold it.
Yeah, but Chris, that doesn't answer my question.
I apologize. What was the question?
The question is,
There's no piece of paper required when you
so you
transfer.
just say here, the gun's transferred.
Certainly if you go through an FFL, then there's a bunch of paperwork.
Yeah, right.
Right. But if you were gifting it to your son, say,
No.
How about on the opposite thing? Your son walks in, takes 2 or 3 weapons and walks out.
Steals without
So
permission?
now, here's my scenario. So now, am I responsible because I didn't have my guns locked and ammunition in a different place? Well, let's say I was in the hunting camp and I was hunting. And my son walks in, takes the weapon, takes a box of ammunition with it. I know, I know this happens because this happens to me. Am I going to be responsible then for not having my weapons stored improperly if I'm in a hunting camp?
if it's your camp,
Well, it's
I
not,
think that-
let's say it's not my camp.
then I would say probably not, because it has to be a premises that you either own or control. So if you're just, say, a visitor
Okay.
And I'd say probably
So if
not.
it's my hunting camp, I would be responsible. If it's not my hunting camp, I wouldn't be responsible.
If you hadn't stored it properly, you mean? Like, and assuming that becomes, yeah, I think you'd have some responsibility if it was your camp to comply with the storage requirements. But remember, if you have it in your hands, if you're hunting, that's an exception.
I'm sitting around the table. I'm
But,
playing cards and he comes in and says, Dad, I'm taking your rifle. Or doesn't say anything, just walks up with it.
but also so I'm going back to the definition on page 1. So it also would be that Topper would have to, it would be, so when you say your son, we're talking about someone 18 and under or a prohibited person is likely to gain access to that firearm. So if you're in a hunting camp with 4 adult men, one of which happens to be a son, but he is an adult, and there's you know them, their family or whatever, and you don't have that gun secured and something happens, can you be held criminally negligent because they're over 18 and they're not a prohibited person?
The answer is no. If it's, and it's 18 or over, actually.
18 or over.
Under 18 only. But yes, no, if it depends upon status being that you think either a child or a prohibited person can gain access to it. So if there aren't any reason to think that there's kids around or that there's prohibited people around, then no, the storage requirement wouldn't kick in.
So if they're over 18.
18 or over.